Hello. So my name is William Sanjaya. I'm from semester 2 and I'm taking international law class. So this is some of the few projects of Purina for international law and Puyokebet as the second docent. So I'm gonna talk about the last project about videography. What is international law? First, before we talk about international law, we should talk about what is law of nation. So law of nation is the set of rules by set by government for the society to encourage justice, certainty, and utility. If they follow, there's right and obligation. If they're not following the rules, so there will be sanctions. So we're gonna go to what is international law. The meaning of international law, there's two meanings. So first one is the modern approach, where it's the body of law that regulates the activities of entities possessing international personality. For the second one is the traditional approach, the conduct and relationship of states. So it's between one state and the other state, but it's for the traditional approach. So the division of international law is two. There's public international law, and the second one is the private international law. For the public international law, so it's like one state, we know each other state, so it's not as private. So it's not like a private national law where the people and people in the court. It's different with the international law. So the international law is a conflict of law, the body of law that regulates the relation between person and entities in different states. And I'm gonna talk about the sources of international law. The primary sources, there's three, where it's international treaties, custom, and general principles of law. So for the international treaties, there's one state and one state. They have a peace treaty or maybe military agreement of the treaties. Second one is custom, and third one is general principles of law. So the customary international law is from the consistent practice of state opinion juries. So the third one is general principles of law. It's the legal principles common to the major legal system. So there's Article 31, State 1. A treaty is interpreted for good faith, its object and purpose. For its subject, there's 5 subject of international law. Whereas first one is the state. How about we talk about the theories regarding international law. So first one is the monism approach and second one is the dualism approach. First one, monism approach is where two legal systems become one. So it's international law and the national law becomes one into a single legal system. But for the dualism law, it's international and national law are distinct legal orders where they're not unified together, so it's different from each other. For the monism approach, example of the country of monism approaches, first maybe it's France, and for the dualism maybe it's our country, Indonesia. So sorry. So we're gonna talk about subject of international law. So there is 5 subject for international law. State. So I'm gonna talk about state. So state should have a legal personality in order to be a subject of international law. So first one is a permanent population. Second is territory. 3 government. 4 sovereignty. 5 the capability to enter into a relationship between states, and 6 one is recognition by other states. First one, permanent population. So permanent population means like there's people living in your state. And second one is territory. So there's land, sea, and space in your state. Third one is government. Fourth, sovereignty. Fifth one is the capability to enter into relationship between states. Sixth one is recognition by other states. So in recognition of other states means can't be it can't be withdrawn. So it's people recognize you in this state. So it means in international organization you become one state. Example for it is United Nations, where United Nation recognize Indonesia as a state. And second subject of international law is international organization, where international organization is organization whose members consist of states, have a significant membership and are structure of organization. So there's the court justice, and the membership. So example of the international organization is the UN, United Nations. So there's a lot of state who went inside the UN and become part of the UN. Third one is the Holy Throne. Holy Throne is a law stated in Lateran Treaty in 1928. So it's have its own sovereignty as a subject of international law, and it cannot be attacked by any state in time of the war. So one place that I know for the Holy Throne is only one, is the Vatican, where it's in Rome or Italy. Fourth of the subject of international law, so it's the belligerency. The meaning of belligerency is a group of people who make an action to separate themselves from sovereignty in any state. They possess half of national territory and real authority. So example of it, it's in our country, maybe it's GAM, Gerakan Aceh Merdeka. They want to make in its own self Aceh to separate from themselves, to make a new sovereignty state for themselves who live in Aceh. So the fifth one is the individual. So fifth one, individual, is stated in the Rome Statute. So okay, we're gonna going next. So it's recognition of state and government. What is recognition for first? So I'm sorry. Recognition generally refers to one state willingness to establish or maintain official relation with another state or its government. So it's from the slide, but from my meaning, it means like we got recognized by each other we got recognized by other state, so that they know we are a state. That's my meaning. For me, and then is it important here to state to obtain a recognition from other state? For me, yes. So maybe the example is Indonesian, Germany, and French. Maybe Germany recognized us, Indonesia, as a state, but France didn't recognize us as state. So that means France and Indonesia can't do any multilateral business cooperation, or maybe some stocks holding in France or vice versa. So the recognition of state, there's four actually. First one is the express recognition. The express recognition or the direct recognition actually is as I can say, it's an international treaty where diplomatic letters or notes, statements or telegrams, even maybe people who go there just talk about the recognition of this state maybe. Second one is the implicit recognition. So it's sending a diplomatic agent having talk with an official or head of state. So it's our diplomatic agent would talk with the other state to make us recognized by other states. The third one is collective recognition. It's actually more than one countries in an agreement, so maybe it's via international treaty where there's a multilateral conference. Maybe the Asian countries, where it's at 18 April 1975 recognized Cambodia. So the fourth one and the last one is the premature recognition. So recognition for one state where the state is not mature enough. So recognition is not given by this to this state because it's not mature enough. So maybe they don't have any complete constitutive components. The one that I know is Sokovia, country named Sokovia in Europe. Okay. For the types of recognition of government, first one is de facto recognition, where based on the facts. So de facto is by the facts, and it's not permanent, and it's more than one government. De facto and the second one, de jure, is the final. So it's the ruling power that recognized by the state. Only one government, and it's legally recognized. So I'll make an example. Maybe France, there's belligerency in their country. So there is A, the belligerency, B, and the government. The A is recognized by Indonesia. I mean, you got more power in France, the belligerency. So Indonesia recognized A as a state, but not B as the government of France. So it's not permanently recognized. And then after, maybe there's a war, or maybe they went to international court jurisdiction for any problems, so they went to ICJ. Maybe after they went to ICJ, so the ICJ concludes which one is the best one for France. Maybe it's the A1, or maybe it's the B1 for the government. Maybe if A took the place in the government, so France itself, I mean Indonesia itself, recognized it as a state, and that is the de jure state, where it's only final and only one government. The third one is recognition of belligerency. So belligerency, as you know, it's people, group of people who wants to separate it from its own territory, or in a state, to make a new government and a new state. So recognition of government is the third one is recognition of belligerency, where belligerent groups seize power in its own for a portion of it. So the fourth one, recognition of national liberation movement. At first, this is not bigger as belligerency, where belligerency is bigger than the national liberation movement. So maybe it's like the smaller version of belligerency, or maybe the rebel forces. Yeah, national liberation movement is the rebel forces. It's not big as belligerency, where they wanted to separate each other from the state. Yeah. And for the national liberation movement, it's not applied on universally. So it's not applied everywhere. So we're gonna talk about state responsibility. What is responsibility actually? Responsibility is associated with obligation. State responsibility under international law means obligation of a state associated with its international status. Actually, responsibility is a liability for a state. So, fundamental elements of state responsibility. First one, the existence of a legal obligation recognized by international law. Second one is an act or omission that violates that obligation. 3. Some loss or damage caused by the breach of obligation. So, there's two types of state responsibility, where first one is there is international conduct, international conduct, there's purpose in it, but negligent conduct, there's negligence. So it's maybe negligent. So we're gonna talk about sovereign immunity. Sovereign immunity is where this how to explain it. One state cannot assert jurisdiction over another state on its court. So, for the scope of sovereign immunity, state, head of state, state government, agency that are conducting state business. So, there's immunity where exemption of a head government and the head of government cannot be prosecuted. It's a privilege by other states. So there's two types of immunity. First one is absolute immunity, and second one is restrictive immunity. The absolute immunity is is the foreign head was not subject to any civil or criminal prosecution during and after leaving the office. Second one is restrictive immunity. Most states no longer extend absolute immunity to entities owned or operated by foreign governments. In the restrictive immunity, most states currently apply for some form of restrictive standard for resolving sovereign immunity questions. So maybe in the restrictive immunity, sovereign versus private, public versus private. So it's more to application of absolute immunity for them. So we're going next, where we're going to talk about human rights. So human rights is, for me, is a fundamental of basic rights or basic needs that given by God. But as I heard, or maybe I read from some article in the internet, there's a bit difference from my version of human rights and their version of human rights. My one is where the human rights is enacted by God and it's given by God. But for them one, from the article which I read, it's a right possessed by individual, cannot be withdrawn by states. So okay, I'm going to talk about the human bills of the human rights. First one is the 1948 Universal Declaration of Human Rights. It's the first one that where the universal declarate for the human rights. So it's the right to live, liberty and security, or maybe economic change. You can work there, maybe live and enter your own country, freedom of slavery and torture, right to vote, and other else. Second one is the two optional protocols of ICCPR. Third one is the 1996 International Covenant Economic, Social, Cultural Rights. Fourth one is the 1966 International Covenant on Civil and Political Rights. So there's a lot of human rights treaties in the whole world. Maybe it's in Europe, Latin America, or even in Africa. So they have each of human rights treaties in Europe. The Europe is the ECHR, where is Euro Human Rights Convention, stated as the civil and political rights. For the Latin Americas is 1948 Charter of Organization of American States, or maybe people say it's OAS, not OSAS but OAS. And third one is Africa's human right, where it's 1986 Africa Charter for Human Rights. Okay, next one is I'm going to talk about refugees. Refugees, as I read from the Article 1, a stated 2 of the 1951 Geneva Convention on the status of refugees is refugees or any person who, owing to well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group of political opinion, is outside the country or of his nationality, and is unable or owing to such fear is unwilling to avail himself of the protection of that country. so or unwilling to return to its own state. So for me, refugees is maybe I'm from Syria, maybe or not, Palestina. So I went to Indonesia because Syria got a lot of war. So I want to seek asylum or maybe peace in Indonesia. So that's why I am willing to return to my own state where I don't have any peace in there. So I don't want to go back to that country maybe. So legal status under the international law is the 1951 Convention of Geneva Status. So I'm going. The next one is jurisdiction. The meaning of jurisdiction itself is official power to make legal decisions or judgments, or even power of state to affect person, property, and even circumstances within its territory. So there's 5 jurisdictional principles. First one is the territorial principle. Second is nationality principle. Third one is the passive personality principle. Fourth one is protective principle, and the last one, fifth one, is the universality principle. So the first one is the territorial principle. It's a principle of international law where its under sovereign state can prosecute criminal offenses that committed within inside of its territory or state. So there's 2 forms of territorial principle. First one is the subjective principle. So first one, Singapore adopt a statute that makes it crime for anyone to commit an act murder within its border. X kill Y in Singapore and Y is murdered by X in Singapore, and that means X could be prosecuted by Singapore laws. But example of and the second one is the objective principle. Rocky is a drug smuggler. A few days back on the back of Guri River, border of Singapore and Malaysia, Rocky saw Federal Drug Enforcement's Agent Jack. So Agent Jack arrested Rocky brother in Malaysia for drug smuggling. In revenge, Rocky shoots and kills Agent Jack in cold-blooded. That means Rocky itself could be prosecuted by Malaysian law, even though they in the border of Singapore and Malaysia, but still they caught Rocky and the brother in Malaysia. The second one is nationality principle. Nationality principle is recognized that a sovereign state can adopt criminal laws to govern conduct of sovereign national while outside the sovereign borders. The easy way is maybe maybe Indonesia does not legalize gambling in the whole country, and Singapore legalized gambling. Me as myself, maybe I'm gambling in Singapore, but notwithstanding gambling is legal in Singapore. That means I have committed a crime in Indonesia, but not in Singapore. Okay. Third one is passive personality principle. So it recognizes that sovereign can adopt law to apply conduct of foreign nationals who commit crimes against the sovereign nationals, where the sovereign nationals are outside the sovereign territory. Example of passive personality principle. So the passive personality principle actually a lot of examples or maybe things concluded in passive personality principle actually is most to where they crime against others, the sovereign national, where it's outside the country. So example of it is maybe X bombed the embassy of United States in maybe Wakanda, maybe, and flee to Switzerland. In Switzerland, X got arrested for his doing and got prosecuted in Switzerland. That means where X is not Switzerland, but it could be he could be prosecuted as there because of the acts he's doing. The fourth one is protective principle. So it's rules of international law that allows jurisdiction over a person whose conduct outside its boundaries, so it's outside of the state territory, but threatens the state security with the government function. So maybe I'm going to talk about maybe the Black Panther maybe. Example, I'm sorry, but I'm going to take example in the Black Panther for the protective principle. So T'Chaka is the ruler of Wakanda, and M'Baku is the rebel group outside of Wakanda, and he wants to kill T'Chaka, and rebels got bigger and bigger, and T'Chaka threatens to persecute the rebels group because M'Baku itself threatens the state security with the government functions. So the fifth one is the universality principle. So universality principle recognizes sovereign can adopt criminal law that applies to conduct performed by anyone in the world by nation as being universal concern. The universal concern is actually usually maybe it's terrorism, genocide, or maybe other else. So example of university principle. Maybe I'm the general of Indonesia. So me as myself, I have killed thousands or genocide over these Indonesian tribes. So I flee to maybe Switzerland or maybe Germany. So I caught by the German government because of genocide of a tribe. Because genocide is an international concern. So that is the five jurisdictional principle. So we're going to talk about maybe okay, maybe that's all. Thank you for watching. I'm sorry for misspell words or misspell pronunciation, and I'm sorry if maybe there's some words or maybe some meaning that I confuse it. Okay, thanks.